Welcome back. Michelle, let's talk about the estate planning mistakes that celebrities make and what we can learn from them. The first one is Aretha Franklin, right? She died 2018. She had 4 sons. Now, she didn't have a will or she had an invalid will. I've read both. I've read that there was a bunch of handwritten, unreadable ones. So walk us through what happened.
So as you've touched on, Aretha unfortunately passed away at the age of 76 in 2018. And when we look at the circumstances that led up to her death, we always have to ask why. Like, why did this happen? So we know, it is rumored, or because I'm not her doctor, I haven't confirmed, but Aretha actually had been diagnosed with pancreatic cancer. And the one aspect about Aretha that most may not know of is early on in her career, she didn't have a positive relationship with a business manager. So she took everything personal. She was a noted control freak over her career and in terms of personal life. And we know that she had 4 sons. The eldest did have some special considerations. And when we look at in terms of not planning, I'm sure with her diagnosis, as you touched on, there were 3 handwritten pages. However, none were dated. So in terms of which could be identified as her last in terms of wishes from that end. And when we look at this, the consideration is why. She did have wealth. She did have a beneficiary that had special considerations. She, in terms of oversaw all aspects of her career. All right, why in terms of her legacy, in terms of her state, did she not go take that next step and oversee and outline what she wanted to happen? Because it did go back and forth in terms of which was her final intentions. But given the fact that it was not a proper will, no one could identify what was her last will and wishes, that it meant court delays, it meant legal fees, it meant her privacy, which was valued by her, was given no regard. It also meant she could not direct as to the distribution or who would oversee her estate in the fashion or direct as to what she wanted to happen. It basically went through the courts and in according to a formula. And when we take this back, we think, oh, celebrity, have all of these, she had advisors, to look after her, but that wasn't the case.
Yeah.
And what was the result? The result was, so if Aretha had lived in Ontario, and remember I said will and succession acts are a provincial mandate. If she had lived in Ontario, her estate would have been locked for at least a year. And I'm sure Aretha was supporting her son during her lifetime, provided the care and oversight that he needed. Well, in that lockdown of a year, it would be up to the courts to decide whether or not to continue that care or oversight, or who would continue to overseeing the affairs of the eldest son.
So is, in this case with no will and she didn't have a spouse, would it just be equally divided amongst the 4 sons? And is that what happened? Has it been resolved?
So it's under in terms of seal. Now, if she had, because she had no spouse, and that's actually a common fallacy, like in an intestacy situation, most people assume, oh, my spouse is going to get everything. No, that's not the case. And it varies amongst the Canadian provinces and territories. There is something called a preferential share that a spouse or common law partner would be entitled to. And also the definition of spouse versus common law partner is not treated the same across the Canadian provinces and territories.
That's right.
And the preferential share varies amongst the provinces and territories. So in this instance, it is believed that her estate ultimately was divided amongst her 4 sons. But the question is, did her eldest son have the capacity to oversee his affairs? And, you touch on beneficiary needs. All right. What if her children had been minors? Or in the instance of her eldest son, is he a vulnerable person? If appropriate oversight is not outlined in that instance, across Canada and the various provinces and territories, those particular mandates or inheritances would naturally go to the government and the respective in terms of oversight body that oversees vulnerable persons or minors.
Okay.
In terms of, and who may not direct or care for that beneficiary as the testator would want.
Okay. We're going to take a quick break, but I guess the conclusion is one, sometimes a handwritten will might not do it. You have to know, because it can make it invalid, can't it?
Well, and it's up to date.
Yeah.
Like in terms of when you look at life changes.
Yeah.
So yeah.
All right. Okay. We'll continue this conversation. We'll be right back.